For our last case, which is DS versus Agency for Persons with Disabilities.
It was getting close.
Good morning. I'm Richard Filson, representing the appellant. May I proceed?
You may.
The appellee Agency for Persons with Disabilities administers the state Medicaid program as it applies to developmentally disabled persons, of which DS is one. They particularly handle the approval of services, including supported employment services granted to such individuals. One of the models, there are two models. One is the individual model, where there's more one-on-one job coaching, that sort of thing, and the other one's a group model, where groups of developmentally disabled persons go out and do group activities, group-type jobs like cleaning, etc. The individual model is what we're here talking about today, and that model is divided yet again into two phases. One is phase one, which is not funded by Medicaid. One is phase two, the other is phase two, which is funded by Medicaid. The difference is that, as I'll get into during this argument, is that phase one is essentially trying to match a person to a job, getting them job training, getting them set up in the job. Once that person has reached job stabilization, they're then shifted to phase two. Only at that point does Medicaid come in and pay for the services. And phase two includes services such as systematic job supports to keep the person in the job that they've been placed in.
And can there properly be movement back from phase two to phase one on the
It may be necessary. There's no mandate in the and hopefully I only have to say this once, the handbook, which is called the Florida Medicaid Developmental Disabilities Waiver, Coverage, and Limitations Handbook, which I'll refer to as handbook from now on, provides that it may be necessary if there are too much stresses on the person.
But what it says is it may be necessary if the supports needed to maintain employment for a given person become too great in intensity or duration. Isn't that what it says?
Yes, that's exactly what it says. In other words, it may be necessary to move back if those types of situations are met. In this situation, the Medicaid through APD provided Mr. Shell supported employment services under phase two for over 2 years in his job at Publix. The supported employment consisted of a job coach that would go. The record reflects exactly what the job coach did, assisting him in keeping his job. The entire denial of this claim in Appellee's argument is that DS never reached job stability and was improperly receiving phase one services, which aren't funded by Medicaid, for the entire 2.5-year period, that he never, ever reached it, and that this was an improper application of the law or improper interpretation of the law. This all came about, the denial, after APS Healthcare Incorporated was hired by the state to come in and review Medicaid cases. APS Healthcare Incorporated reviewed this case and indicated that Mr. Shell, or DS, had not reached job stability, therefore was improperly receiving Medicaid services. The handbook is a handbook, but it's called a handbook. The title of it is a handbook, and it talks in terms of typical averages, mays and not shall. However, the Florida Administrative Code, and I think both the appellant and the appellee agreed, as well as the administrative law judge, found that it's controlled because the 59G-13.080 subsection 12 of the code basically makes it the law. As to whether or not a person gets Medicaid services, what those services are, how they're defined, what the limitations are, and what the exclusions are. The handbook and the court references in its recommended order, indicates that the number of hours of intervention is intended to diminish over the first few weeks of employment as a supported employee becomes more productive and less dependent on paid supports. Phase 1 ends after demonstration that the supported employee has established job stability. This is very important. I hate to read, but I have to because this is fairly key, and I think it's the issue in this case. The stabilization period begins when the person has achieved satisfactory job performance as judged by the employer, in this case Publix, provider, that would be the provider of the supports, the vocational rehabilitation counselor, if applicable, there is none in the record in this case, and the supported employee, who would be Danny Shell, or when the need for paid supports diminishes to fewer than 20% of weekly hours of employment. The administrative law judge, in his recommended order, reciting that particular provision, stated that Phase 1 ends after demonstration that the supported employee has established job stability and, not or, and requires support for fewer than 20% of weekly hours of employment. It goes on in paragraph 10, this is on the record 182, petitioner has not demonstrated job stability due to his constant need for one-on-one support. So the court...
I guess the concern I have about the argument that you're making is that if, and this is, I think what the hearing officer said, or where he got, was that if you read the handbook as a whole, it does not seem to contemplate 100% one-on-one support in Phase 2. I mean, it talks about diminishing hours and all that kind of thing, and then the language that you read earlier suggests that if support becomes too great in intensity, which to me means closer to 100%, then you may need to go back to Phase 1. When you read everything, it seems to suggest that someone in Phase 2 should be more independent than requiring 100% support.
Well, and again, these mays, shalls, this thing's a handbook, and it was written, it's titled a handbook, it's written as a handbook. Clearly the legislature and APD, in its rulemaking authority, could actually write a rule or craft a statute that we could interpret because they really are statutes and they really are rules, yeah. Or they can take a pass and say, okay, we're going to adopt this handbook, and that's the rule now. And that's a problem in this, because I mean I agree that throughout the book, you know, may, shalls, aspirations, goals, you know, mixed in with some limitations. So there are a couple limitations. One is the one I just said. In other words, if you don't have this consensus, then that's a problem. But in this particular case, there was no consensus among these individuals that he had not reached job stability. In fact, what the record shows is the testimony that was before the court was that Danny Shell had improved over the course of his employment, was improving all along, getting better over this 2.5-year period.
Well, but the requirement can't require consensus in every case, can it? Because that would mean somebody who was improperly in the program could stay in it as long as they wanted.
There's two ways. There's an or there. Okay. There's an or that the determination as to whether they've reached job stability is this consensus decision between the various parties I described, or when the support's diminished to 20% of weekly hours of employment. Now there is another limitation, and it's a big one, and I think it's telling in this case in terms of the number of...
Well, I think maybe Judge Palmer's question may have been directed to your argument at page 4 of your reply brief that there could not be termination unless there was consensus among all the players that you mentioned. Wasn't that your argument?
No. See, what I'm talking about is the stabilization period. In other words, whether or not they reach job stability. That's a different argument I'm making. That's a different part of the handbook. In the limitations section, it does say, as you suggest, decisions to change the duration or intensity of the service to less than twice monthly contacts in the individual model of service delivery or to terminate supported employment services shall only be made through consensus between the recipient receiving services, that would be DS, his guardian, his mother and father, and vocational rehabilitation counselor if applicable, the district or waiver support coordinator, and the provider. So that's a different issue. In other words, yeah, there has to be, there would have to be a consensus to terminate made between those individuals, but it's a different
But it
issue
is your
as to whether or not
argument,
to
it is your
reach-
argument that there can never be a termination of benefits unless all those parties agree. Isn't that your argument?
That's what it says, yeah, because that's what the handbook says. You know, whether or not it should say that, I'm not here to argue. It does say that. And also, it provides in a limitations section, a specific limitations sections on page 101, the Phase 1 supported employment services are limited to 8 hours or 32 quarter hours per recipient a day. So that's 8 hours a day. Phase 2, which is what we're here talking about, supported employment services, are limited to 8 hours or 32 quarter hour units per recipient per week. So there's actually a limitation section in the handbook which basically says, okay, if you qualify, if you have job stability and you're receiving Phase 2 services, you're limited to 8 hours or 32 quarter hours units per recipient per week. Now, I can see, before anybody asks me, that the support coordinator asked for 10.89 hours, and it should be 8 hours, because that's what the handbook says. That is a limit. So going back to the earlier question that you had, though, you said, well, isn't it contemplated that this is too much? But my answer to that is no, because in the limitations section, he's just barely above that. And the reason is, as the record suggests, is that he does only work 8 hours per week, but he gets there early, and there's a job coach there early for him for like pre-meetings and after meetings at work. And during the holidays, that bumps it up from 8 hours per week to this 10.89. But I will agree that it should be 8, and that amount should have been approved. But again, there are two separate issues. One is, did he reach job stability? The handbook clearly says that there's two ways you determine that. One is this consensus between these individuals who are enumerated in the handbook, or if the support's diminished to fewer than 20% of weekly hours of employment. As to that, I believe that the judge's decision was solely based on that. In other words, it wasn't based on whether or not this was a proper termination. It was based on his conclusion that, and as he says in his order, that there's an and there instead of an or there.
Was there record evidence that this consensus was reached by all the people who are listed in the or portion of that?
The only record evidence that exists as to that issue is that the supported employee testified, the mother of the supported employee, a guardian, testified, the providers testified, and as the court recognized in its findings of facts, which I don't contest, all of these individuals indicated that he was improving in his employment. And so that it was not and also he had been provided these services for over 2.5 years.
What's the relevance of that? If somebody comes in 2 years after the effective date, does an analysis, and let's say they decide he never should have been in Phase 2. Is it relevant that he got 2 years worth of benefits? Is it some kind of an estoppel argument? Or you get to look at it and see whether or not he ever should have been in the program?
Well, I suppose you could take the position that, okay, it was just a horrendous mistake, but the First District Court of Appeal in this Courts versus Agency for Healthcare Administration case that I cited dealt with it with a fairly similar issue. In that case, the Agency for Healthcare Administration had approved home companion type services and had for a long time, for I think a period of years. In that case, they came in, did a review, and said no. That was improper. We made a mistake. What the court essentially said is that nothing in the agency's interpretation of the scope of companion care contained in the waiver application changed. That simply contending that a past interpretation was a mistake and that ACA, in that case, had changed its mind is insufficient. Further, in this particular case, is undisputed in the record that the additional companion care hours were essential to ensure the appellant's health are necessary to prevent regression, etc. The court went on to state that it is clear that ACA's decision to deny appellant's benefits when it approved those same benefits since 2002 was simply a change in its established policy. Further, it is undisputed that in the record that this policy change was made without rulemaking or explanation on the record. and essentially held that you can't, a bureaucrat simply can't change its mind, that there's got to be some rulemaking in a situation like this. So to answer your question.
Here's my concern, or
Okay.
why it might be, I think my last question was relevant. Since you said what the record testimony is he was improving on the job. Well, if you start from the premise that he was properly put in the job, so he met the requirements on day one, evidence that he's improving would say he still met the requirements. If, however, you can look and say he shouldn't have been put into the program to start with, simply having evidence that he is improving in the job wouldn't necessarily mean he got to the point of the threshold to be in the program. Do you follow my logic?
Yeah, I hear.
So that's my concern about what the relevance is of what they did 2 years ago.
Let me just go back to the Bellino case as well, and the standard of proof in a case like this is obviously on APD because they're terminating benefits. So when it comes to providing evidence like that, I would contend that APD has the duty to come in and show that, not Mr. Schell. Again, I'd like to address one last thing. I understand that this is a kind of a loose guide. In other words, it could be tighter, but that's not my client's fault. It's not his responsibility. The burden in this case is on APD, not him, and he meets the requirements as set forth in the guide as it's written. And there is nothing in it that would limit him. In fact, the limitations section, it could say it if it wanted to, and it doesn't. Thank you.
You have about 4 minutes left.
Good afternoon. I'm Jeff Mull with the Florida Attorney General's Office representing the agency. And if I may proceed. Judges, the issue in this case, it revolves around the funding issue. And it's clear in the record, it's clear in the order. If it is a Phase 1 activity, then it's not funded by my client. When the very first documents went out in this case saying, wait a minute, this isn't funded by us, and that was the rejection of the claim for funding in this case.
Is it correct that the handbook is the only adopted rule that governs the program and your decision-making in the program?
It really is, Judge. The handbook.
Where in the rule does it say that you don't fund 100% one-on-one companion services in Phase 2?
Well, actually, it is, different terms of art, but what it said, it's not companion, it's supported living. And there actually is, and it was cited in the record, I'll get it for you here. Phase 1 supports, and it says moving to Phase 1 supports, but Phase 1 supports must include a referral to vocational rehabilitation or the local school system as applicable to seek required funding. Medicaid waiver funding shall be used only if these alternative resources are not available. And in this particular case, and that's in the record at 186, and it's part of the handbook that's covered, that defines this section is from about page 98 to 103 of the handbook. And yeah, it's specifically in there. And that's why this is a funding issue.
What you read didn't sound like it was saying that Phase 2 cannot be one-on-one, full-time support, 100% support.
Okay. There's two different issues. The first issue is who pays for this, if it's Phase 1 or Phase 2. And if it is Phase 1, if it is Phase 1 activity, which is what the facts that the court reached, the conclusion of facts, said this was Phase 1 activity. It's also what both witnesses, there was a witness for my agency that testified that what he was doing was Phase 1 activity, and then the appellant's witness, if you look at the transcript between pages 59 and 63, says, yes, this is Phase 1 activity that we're involved in. So if it is Phase 1, the funding is not from our source, it's from vocational rehabilitation and the education system, and they needed to go there and exhaust that. Then if that's not available, then they can come back and say that. But in this particular case, that's never done, and the issue only is, well, do we fund it? And the answer is it phase 1 or phase 2? And that gets to the second issue that you're asking about. Is this phase 1 or phase 2, and can it be considered phase 2, what he's doing? The answer to that is everybody's talking about how loose the handbook is, and the handbook is somewhat loose. But this particular issue covers 4 pages of the handbook, and it lists what phase 1 is versus phase 2. And in phase 1, examples are given, and in phase 2, examples are given. Now, the court touched on it a little bit earlier. The situation you wouldn't want is exactly what you see in this case. Here's phase 1 activity: intensive, systematic, on-the-job training and consultation, focus on building skills. And they talk about, when you're reading this section, when you're reading these sections, pages 98 through 103, they talk about the examples being based 6 to 8 hours a week on the intensive training. It starts out 6 to 8 hours a day. 6 to 8 hours a day. And what they're talking about is an 8-hour job. If this were a full-time job, when you first start phase 1, this is a full-time job, you first start phase 1, you're looking at an 8-hour day, and you can have one-on-one in phase 1, 6 to 8 hours a day. Now that's supposed to diminish over time. And in the example they give, the 6 to 8 hours lasts for a matter of a week or 2 weeks, and all of phase 1 typically goes 24, 25 weeks, but you can have that intensive one-on-one work with your coach or your paid employment support during all of phase 1 activity. But at some point in time, and if you read the statute, or if you made it too black and white, you might kick somebody out if they never pass phase 1. Nobody wants that. Nobody wants him to be kicked out if he never gets out of phase 1. You can still have phase 1 activity working with him the 6 to 8 hours a day. But to move from phase 1, which is funded by Voc Rehab first and education system first, to phase 2, which is funded by my client, changes have to be made. As you progress through phase 1, you go to a point where you start to diminish from an 8-hour workday, having somebody with you 6 to 8 hours a day, down to eventually 1 to 2 hours. And eventually get to a point where you don't have to be working with the individual. If you're the supported employment coach, you don't have to be there the whole time. You can be with other people. And eventually you'll reach a point where everybody's happy with the performance, we're going forward, we're making improvements, and the hours start to diminish to a point where you're only there coaching him for about 20% of the time that he's there, which comes back to that about the 1 or 2 hours a day. Then when you hold that area where you're 1 to 2 hours a day, and you hold it for a sufficient period of time, you've demonstrated stability. And once you demonstrated stability, you can move on to phase 2. Now, phase 2...
Once you're in phase 2, how does somebody get removed from or terminated from phase 2?
Phase 2, they explain that if it becomes necessary...
Could I just ask?
Yes, I'm sorry.
How did he get into phase 2?
The record isn't clear, and this was brought up earlier, is it relevant or not? Is it relevant or not? What we know from the record is the documentation. By the way, I don't think he ever was in phase 2, but I can't tell that from the record, because what happens in these cases is they're reviewed annually. A new plan is put forth annually. It may have the same factors as the old plan, but it has to be reviewed annually.
Well, were his services paid for as though he were in phase 2?
It appears that way.
Well, somebody must know where the money was coming from.
Well, I'm sure it was coming from, well, I actually don't know from the record. I can make assumptions that aren't in the record, and I'm hesitant to do that.
Well, let's assume for purposes of discussion that he was previously in phase 2.
Well, I think that's where I want to go with this, is
Okay,
because
all right.
if
We'll
you look
assume
at
that he
If we
was
don't
in phase
assume
2.
that, I don't know that
Yeah.
you have standing to even be here. 'Cause
Well,
what's your
I think it's interesting,
Right.
because I think two things happened in this case. First of all, in the first document where my client said, wait a minute, What you're describing, what you want here, one-on-one, full-time, intensive, is a phase one activity. We don't fund phase one activity. So, and they actually put this in the document. They said, it appears that this may be a case where you've gone back. Not knowing what it was, it looks like you've gone back from a phase two to a phase one, because what you're asking for now, at this point in time, is one-on-one, very intensive phase one work. And so at that point, when it was reviewed for this particular point in time, they said, wow, this is phase one. And if he was receiving phase two, it looks like he's gone back, but we don't have that in front of us because that's not the issue. The issue is, what are we doing for this coming year? Then the court, the administrative law judge, in his order, specifically says the same thing. After reviewing all the evidence in front of him, talking about everything that was relevant to this case, the administrative law judge comes back and says, this looks like a case where phase two, it looks like he's regressed back to phase one.
What is that, I didn't mean to interrupt Judge Palmer earlier, and maybe he can ask a better question, but how do you, what is the procedure for going from phase two to phase one?
And again, that's included in the rules, and it sets up, again, they give you, it isn't as loose as it seems, because they tell you, if you're in phase two, you should have worked to the point where everybody's happy, but you don't need intensive services, as Your Honor said earlier. You don't need the intensive one-on-one services. In fact, it gets, if you use the typical average in phase two, quoting the rule, during phase two, the service levels needed per supported employee vary according to the individual needs, but typically average 1 to 2 hours per week, not per day, per week. And it goes on to say that under those circumstances, the supported living, or the coach, the employment coach, can go from just being with you one-on-one to handling one staff person supporting up to 20 employees. So you can see in phase two, there's very little involvement, very little intensity. In fact, you'll never find in the description of phase two words that even suggest one-on-one the whole time of employment, 100% of the time. This was clearly a phase one activity.
Let me ask you this.
Yes.
The petition that started this whole process in the before the administrative law judge, tell me what remedy is asked. What was the petition to do? Was it to say, we want to move them from phase two to phase one? Was it to say we don't want to fund these activities because they're tell me what the nature of the original petition was that started all this.
Well, to answer your question, using the procedure that's in place, every year a support plan comes up, a new plan comes up, and the petitioner's waiver support coordinator comes and says, here's our plan for the new year, review it, approve it or don't approve it. In this case, it was not approved. They said, wait a minute, what you've given us to look at is a phase one activity, and we've reviewed everything you've given us. It's a phase one activity, and based on what we're hearing, it sounds like you're slipping back. What do? So they said, no, we're not going to fund it because we can't. The rule says we can't fund phase one activity. So you need to go to voc rehab or education, exhaust that, and then even if you exhaust that and it's not there, which we believe it is, come back. Then what happened is with that rejection or that suggestion you're at the wrong funding source, that gets more into the formal petition, which is, wait a minute, we don't like that response. Rather than go to voc rehab, rather than go through the services you're telling us to, we're just going to take an appeal on it. We want a fair hearing on it. So we're going to a fair hearing and we're requesting a fair hearing, which may be more closer to a petition.
So DS seeks to have a review of the denial of benefits by your agency.
Yes, Your Honor.
But in those proceedings, you then have the burden to prove that the denial was appropriate.
Right, and that's why witnesses were called at that hearing, and the two witnesses that testified on this issue, is it a phase one activity or phase two activity? One, which is their own support coordinator, which they have, that represents them and pays them in transcript through pages 59 through 63 says, yeah, it's phase one activity. And our people said, yeah, it's a phase one activity. And the court, when it reviewed the evidence, found...
Why, if she agrees that it's a phase one activity, did you apply for phase two benefits or phase two monies?
I don't know that, I don't know, I think they applied for benefits. I don't think, and I think they wanted the benefits, and what my client said was, what you're asking for isn't a benefit we cover. We don't cover this benefit, we don't pay for this benefit, Voc Rehab does. I think you're in the wrong place. Okay, that's how my client views this, because my client gets the paperwork from the support coordinator, looks at it and says, wait a minute, we don't fund this, this is a phase one, based on what they've given us. So, at that point, they make the decision and say, you can do something with
And
this.
the basis of the opinion that it was phase one activity was that exclusively based upon the amount of coaching or assistance, or was it based on other things as well?
It's based on the full, all of the pages from page 98 to 103 that define the service, and comparing it to what was submitted, what we want, which includes, as a major part of it, the one-on-one for the full hours that he's employed, which is clearly phase one, but it also goes on to compare it to the examples that are provided. And when you look at that full one-on-one, all the time that he's employed, and you see no change in it, no phase two activity, because phase two, when you read that description, doesn't define this situation or even suggest its existence in any way, shape, or form. You're looking at a phase one activity. Surprise, yeah, in a lot of ways, I wish we wouldn't be here, because I wish they would have gone to Voc Rehab, gone through that process, and get it funded through Voc Rehab, because nobody in this instance is saying, we're terminating this service. We're saying, we can't fund this service, go to the people that can. We want you to have it. It's phase one activity, go get it. And the beauty of it is, this isn't one where an agency's saying, or like an insurance company saying, I'm not covering this, and then another insurance company saying, well, I'm not covering it either, nobody's covering it, and there should be some overlap. This particular rule says, if it's phase one activity, we don't cover it. Voc Rehab and Education does, but if it turns out that when you go back there, they say it's not available because the government doesn't fund it or whatever it is, or there's no funding for it, you can come back. But by rule, black and white rule, we can't until you do that. We can't fund
Let me
it.
ask you about this black and white rule. I mean, to me, it makes no common sense whatsoever to say that you can't terminate a benefit unless everybody, including the person receiving the payment, agrees. But you've adopted this handbook as your rule. That's what it says. Why shouldn't we say an agency has to follow its rules? Follow your rule?
I think, well, the obvious reason is we're following the rule. This is phase one activity that you're asking for this year. We are not terminating your benefit. We can't come in and say, you know what? We don't like what you're doing, stop it. We're all in favor of him getting that service. It's not a question of us terminating. Nobody in this case terminated it, just said, we don't fund it. You're at the wrong door for the funding. We can't terminate it because we don't fund it. We have no say in you going forward and getting it. Get it through Voc Rehab. And
Is this a change in intensity of service, or
both?
it says decisions to change the duration or intensity of the service or to terminate supported employment services shall only be made through consensus between the recipient, his guardian, the Voc Rehab counselor, if applicable, the district, the waiver support super coordinator.
The answer to the question
Is
is
this a termination of supported employment services?
No, it's not a termination. It's we can't fund it, get it from them. We want you to have the service. Get it from them, get the funding for it. And by the way, if they don't have it, come back, show us that it's not funded, and we'll do it then. But the rule is we cannot fund it, period.
But the handbook does allow you to do it if they come back and say vocational services can't do it, won't do it.
It actually says here, Medicaid waiver funding shall be used only, and this comes after a line where it says they must go to Voc Rehab, they must go to the education system, and we can use only if these alternative resources are not available. It's one of the few black and white provisions in the whole book. And it says we can't fund it. Now, but if it turns out the government hasn't funded these other people or given them the funding or there's none left, come back, because then we'll be able to. But before that, we can't by rule fund it at all. But that goes to the next question that you're asking, is this a question of intensity? No. What this isn't a decision to terminate, and it's not us saying there's a change in intensity, but go back to the rule which says, if you are in phase 2, and both the first document that came out from our client saying, this looks like you're back to phase 1, and the judge said this could be one of those cases when you've gone back to phase 1 because the record isn't clear on it, and because you're only doing 1 year at a time. And the suggestion is, if he was getting phase 2, maybe it's because he was there. We don't know. The record isn't clear on that. And I can make assumptions both ways. I don't know that either one's right, but I can make assumptions both ways. But the point is, when support, this is what the rule says, when supports needed to maintain employment for a given person become too great in intensity or duration, it may be necessary to move back to phase 1 if you were in phase 2. So the rule, they're following the rule. They're following the rule.
Let me just ask one other question. I understand and I agree that what this seems to contemplate is a diminution of the amount of time and effort that it takes to supervise the person. But given all we've got here, why can't someone in this program say, all right, instead of having 2 hours of support per day for a 40-hour week, I'm just going to work 1 day, and I need all my 8 hours that 1 day?
The examples that are provided in the outline are provided based on an 8-hour day. And they talk about intensity, they talk about levels of funding. Whoever drafted this specifically drafted it, so funding for phase 1 activity is done somewhere else and not in this program, the Medicaid waiver program, and phase 2 is. It's a decision that they're free to make and made, but the point is when they go ahead and choose their hours, the real question is intensity for that individual worker. And if he needs the one-on-one support, which if you did it 2 hours a week and you only work 2 hours a week, it's still 100% of the time that you're there. And if you went by the example and used it proportionally, you're back to not meeting the requirements of phase 1 and phase 2, unfortunately. I know my time has expired. Thank you very much.
Briefly, it's back to typical averages and may be necessary to move back. These kind of very loose terms of art that are contained in it. Again, the things that I've cited to you are the mandates that are contained in it as to A, what is job stability, and B, how are services terminated. Now, those there aren't any ifs, ands, or buts as to those. Now, in the short time I have, there is a phase 2 definition. And this is it. It's A, B, and C. I'll read the whole thing. Phase 2 is defined as long-term ongoing supports needed to maintain employment indefinitely. These billable support activities include A, ongoing systematic contacts with supported employees to determine the need, intensity, and frequency of supports needed to maintain productivity, social inclusion, and maintain employment. B, remedial on-the-job training to meet productivity expectations, consultation, and refinement of natural supports or other elements important to maintaining employment, and related work supports such as accessing transportation and, this is the part I'd point your attention to, other supports necessary for the recipient to maintain a job. That can frankly mean anything. And I would argue to you that that's in the definition of what is available to a supported employee in terms of supports, and I think clearly that applies to whether it's job coaching or any other type of support. It goes on, or consultation to family members or other members of recipients' support network, including employers and co-workers.
Do you agree with opposing counsel that the statute is set up such that if you go back to get funding and can't get it from the other agency, that then funding can be obtained from this agency?
Without going outside the record, which I'm afraid I'm getting invited to do, I don't think that's reality. Why we're here today is to maintain this person's supported employment. If it was that easy, I would suggest that we wouldn't be here contesting this as we are.
If we were to read C, the way you read C, then there would be no difference between Phase 1 and Phase 2.
You're right. You're right. It's terribly written. It can mean almost anything you want it to mean. But it's clearly a job coach in subsection C is not barred. I don't think a comment, even any type of interpretation of that would bar a job coach for 8 hours a week, as I suggest, because clearly that could be a related work support necessary for the recipient to maintain a job. And I think you could find it also.
It's sort of in context, though. It's sort of that, things of like kind you interpret in like manner. Related work supports such as accessing transportation or consultation to family members or other members of recipient support network.
Okay, well then I could go back to A, which is very similar to the Phase 1 definition with that systematic contacts, which sounds very intensive. Well, they use the same terminology in Phase 2. Ongoing systematic contacts with supported employees determine the need, intensity, and frequency of supports needed to maintain productivity, social inclusion, and maintain employment. And then B, remedial on-the-job training to meet productivity expectations, consultation, and refinement of natural supports, or other elements important to maintaining employment. Probably B is probably the closest to a job coach, because it's talking about remedial on-the-job training to meet productivity expectations and to maintain employment at the last part of the sentence. And that's again on page 100. I just wanted to briefly state too that if you look in the record, page 61, the support coordinator, in response to a question as to, there's a question, which would keep him still in Phase 1, correct? And the answer was, I don't know that I can honestly say yes to that. In the field of practice, phases are a term that's mentioned in the handbook. It's mentioned in a memo by Shelley Brantley. But in practice, phases are old terms that aren't normally used. Then he goes on and talks about the cost plan. So I don't think it's that clear as was suggested.
Do you agree that all of the evidence in the record here says that this is that what he's doing is Phase 1, not Phase 2?
No, I don't agree with that at all, because the definitions contained in the handbook don't mandate that it is Phase 1.
Well, I understand you've got a legal question, but all the evidence, the testimony that was offered at the hearing was all that this is Phase 1. That's what I thought understood.
Well, no,
that there were two people who testified, and both of those who testified said it's Phase 1.
The representative from APD said, in her opinion, it was a Phase 1 activity, and then the support coordinator said that I don't really look at, I don't know what a phase is. It doesn't have that much meaning to me. So that's what the testimony was.
Thank you very much.
Court being recessed.